Hi, this is a presentation about debt claims and whether to make the claim under contract or unjust enrichment. There are many situations where you can be owed money. You could have lent someone money and they have not given it back. You could have provided services that you haven't been paid for. You could have paid for goods and services in advance and those services were cancelled, like holidays and flights, especially in this current situation. Or you could have been overcharged. For example, I'm dealing with a case against Vodafone where they've overcharged on mobile bills. This presentation is to give you basic information on what sorts of claims you can bring in the courts of England and Wales, whether or not this is a small claim. So a typical claim would normally be in contract. Take these three scenarios. I lend you £500 and you agree to pay it back by the 30th of September. I install a new bathroom for you and you will pay for £3,000. Or I provide a service and I agree to charge you £50. Potentially these are all contracts. For there to be a binding contract, there needs to be an offer, acceptance, consideration, and an intention to create legal relations. I'm not going to go through contract law in detail, but let's assume these are all contracts. So in scenario A, I lent £500 and you have to pay it back by 30th of September. If you don't, then you might be in breach of contract and I can sue you for the money. In scenario B, I installed a new bathroom for £3,000. You didn't pay me, that's a breach of contract and I can potentially sue you for the money. In scenario C, I provide you with a service and I charge you £50, but I charge you £100 instead and you pay it. I'm potentially in breach of contract for overcharging you and you can claim the £50 back. But what happens if there's no contract? Or if not, it's not clear that there's a contract? Let's look at these three scenarios. My brother lends me £500 and I don't pay it back. Well, in this situation there might not be a contract because contracts between family members don't really exist unless there's evidence to prove otherwise. In scenario B, I provide a service and I charge you £100 for it and you don't pay. In this situation, you asked me to provide a service, we didn't even discuss a fee. I thought I was going to charge for it, you probably thought you were getting it for free, who knows. Or scenario C, we do agree a fee, I charge £100 but you pay me £1,000 instead. You went on online banking, you've typed in 1,000 instead of £100 and I've got an extra £900 in my bank. These are potentially claims for unjust enrichment. So what are claims for unjust enrichment? Claims for unjust enrichment are equitable claims. They're not claims in contract. The court can deal with these claims at their discretion, but don't be put off by that, because it is a wide discretion. They are also known as claims for restitution. And they are claims where the defendant has gained a benefit at the claimant's expense. It is legally unjust for the defendant to retain that benefit, and there appears to be no defence available to extinguish or reduce the defendant's liability to make restitution. So let's go back to our scenario A. I've received £500 as a lend of money from my brother. There's no contract. I've gained a benefit of £500. My brother's lost £500, so it's at his expense. There doesn't appear to be any good reason why I should keep the benefit, and if I don't have a defence, I should pay it back. In this case, I might claim it was a gift, but if I do claim that, I need to prove it. Scenario B, I provide the service and I charge £100. We didn't agree on a fee, we didn't even discuss it. You've gained the service as the benefit. At my expense, I haven't been paid and I've wasted my time. Is there any good reason why you should get the service for free? Do you have a defence? If not, you should pay £100. But you may have a defence. You might say the service was provided without reasonable care and skill. But of course, you need to prove it. Scenario C, we provide a service and agree a fee, £100, you pay me £1,000 by mistake. The benefit, I've gained £900 at your expense. There probably isn't a good reason why I should keep it. Do I have a defence? Probably not. I should refund the money. But I may claim, as a defence, that I provided extra services worth £900. I'd need to prove it. Two real case examples which we've dealt with. Our client was a brother who was a vehicle mechanic. His sister was the owner of a storage yard. During flooding, the brother asked the sister to store some of his equipment. This was a family favour. There was no contract and no payment for storage. The sister, without knowledge of the brother, sold the equipment and pocketed the cash. There is a claim under the Tort Interference with Goods Act 1977, which we'll cover in a future presentation. But the sister gained the benefit of cash, the brother lost the equipment, and it was unjust for the sister to keep the cash, and the sister had no defence. In this claim, our client was successful and was awarded £23,000. Second example, where we assisted a solicitor who was a defendant. The claimant was a barrister, and this proves that legal professionals can get it wrong. The solicitor and barrister agreed terms that the barrister would not start work to draft documents until the barrister had been paid in advance. Without being paid, the barrister started the work, completed the work and issued an invoice. The solicitor refused to pay. The barrister started proceedings claiming there was a contract. The barrister did not claim for unjust enrichment. The defence was the barrister had breached the contract by starting work before he was paid. That defence was successful and the barrister walked away with nothing, and he also had to pay the solicitor's costs for unreasonable conduct. It was a small claim. So in any claim, you need to think, is there a contract? If no, can you claim the money back under unjust enrichment? If there is a contract, why not make the claim under contract and unjust enrichment as a backup? That's what the barrister should have done. And if you make a claim on contract alone and lose and no backup claim exists, then like the barrister, you may walk away with nothing. You can speak to us, make an appointment online, visit our website or email us to obtain further information and advice regarding these types of claims. Please do check us out on Facebook and Twitter and on Trustpilot, and for more videos and presentations, please subscribe.